What I have for you today is another golden oldie. It's the Wood versus Holden case from 2006. It's not necessarily my favorite, but it is an important case because it gets quoted a lot when you talk about UK tax residence cases, because it's one of the few where actually the taxpayer won in the end, even though the structure itself did not represent much. Wood, by the way, was the owner of a greeting card empire in the UK, and here are some of the cards which I believe that their business has printed. So here is the decision. Let's dig into the facts and see what's going on here. So the structure is pretty complicated because there were a lot of steps that were taken, and let's just go through them. If we look at the structure here on the left, we can see Ron Wood Greeting Cards Limited was a trading company operated by the birthday chain of card shops. Mr. and Mrs. Woods held 380,920 and 40,000 ordinary shares respectively in the company. These shares formed approximately 96% of the ordinary share capital. Other shares were held by employees and a personal acquaintance of Mr. Wood. Okay? And then on 18 October, what happened was that Mr. and Mrs. Wood set up a number of settlements, the Ron Wood family settlements number 1 through 8, and the Gal Wood settlements number 1 through 2, and the Ron Wood discretionary settlement. The trustee of the 10 life settlements was Aglon Trustees Limited. I've not put them in here, and the wholly owned subsidiary of Barclays Trust, who was based in Geneva. Barclays Trust was the trustee of the discretionary settlement, right? And then on 31 October 1995, the trustees of the above settlements incorporated CIL, which was a company in the Cayman Islands, registered in the British Virgin Islands. The share capital was split into A shares, which were held by the interest in possession settlements, as you can see here, and the B shares were held by the discretionary settlement. The B shares carried all the rights to the assets of CIL in the event of liquidating it. Okay, so what happened next was that Ron Wood Greeting Card Holdings Limited was formed as an off-shelf company in 22 September 1995. The company had an authorized share capital of 100,000 one-penny shares. Mr. Wood acquired 200 of the one-penny shares on the 24th of October. A further 90,297 of these shares were also allotted to Mr. Wood, and the remaining 9,503 shares were allotted to Mrs. Wood on 24 October 1995 for cash. And then what happened was that also on the 24th of October, Mr. and Mrs. Wood gifted 45,248, or in other words, half of his shares, and 4,751 shares of her shares in holdings to CIL, that we see what was incorporated on the previous slide. And then what has also happened, but is not shown here, is that on 27 October 1995, Mr. and Mrs. Wood gifted 4,500 and 475 shares respectively in holdings to the Wood Children Trust, a UK resident accumulation and maintenance trust established for the benefit of the children of Mr. Wood. And then in the final slide of our structure, CIL purchased from Aeron BV, a subsidiary of ABN AMRO NV, on 18 July all the shares in a dormant Dutch company incorporated as Eulalia Holding BV. ABN AMRO Trust was appointed as sole manager and director of Eulalia BV. And then on the 23rd of July, CIL disposed of its shareholding in holdings to Eulalia, so Ron Wood Green Card Holdings now became a subsidiary of Eulalia, as you can see here, for £23.7 million plus in the event of a sale within 3 years, and excess of that amount, 95% of such excess, right? So that was the transfer of holdings to Eulalia. And then on the 21st of October, a few days later, there was a sale to the birthday group. And what happened was Eulalia sold its shares and holdings to the Birthday Group for £30,799,384. And the other shareholders, so this must have been Mr. and Mrs. Wood and the other 4%, one would assume, for it was both on holdings and in greetings, sold their shares to this Birthday Group as well. So this is the structure that we end up with. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. So let's see what goes on. First of all, the problem transaction was this one, right? The sale by Eulalia Holdings BV of the shares in the cards business. and just to give a idea of the chronology of the cases, we have the tax assessments from Inland Revenue in 2001. Then we have the special commissioner's decision in 2004. It gets appealed, and then Justice Park orders that the special commissioners came to a wrong decision, and that Eulalia was resident in Holland and therefore not taxable in the UK. And then the Court of Appeal, and this is the case that we look at, confirms that. And if we look at the decisions from the Court of Appeal, it says the revenue appeals to this court. The grounds of appeal are that the judge was not entitled to interfere with the decisions of the special commissioner either as to common law residence or as to residence under the double tax convention. Basically, the judge could decide matters of law but not matters of fact, and they argued that the residence was a matter of fact. But then the Court of Appeal says the judge held that on proper application of the law to the facts, the only correct conclusion was that Eulalia was a resident in the Netherlands. In my view, it cannot be said that the judge usurped the fact-finding role which the legislator has entrusted to the special commissioners. The question for this court is whether the judge was correct to hold that the conclusion which the special commissioners had reached on the facts which they had found was a conclusion which was not open to them in law. In other words, it was just a wrong conclusion. If he were correct in that, he was right to allow the appeal. And then the Court of Appeal goes on to say the legal flaw, and here you already hear that they go with the judge, right? In the special commissioner's approach was to test the decision that was made by ABN AMRO as managing director of Eulalia as if it were not an effective decision. Now, ABN AMRO was the manager, ABN AMRO Trust, of Eulalia, right? The only activity of Eulalia between its acquisition of CIL and the sale of its shares was the acquisition and sale of shares in holdings. There was no basis for refusing to treat a decision on the ground that ABN AMRO made no other decisions. As the judge pointed out, there were two critical decisions for Eulalia to make, and both decisions were, in fact, made by ABN AMRO as managing director. There was nothing else to manage. And then the court goes on and says a further flaw in the special commissioner's approach was to treat the decisions which were made by ABN AMRO as not effective decisions because they were reached without proper information or consideration. But a management decision does not cease to be a management decision because it might not have been taken on fuller information. Or even, if it seems to me, because it was taken in circumstances which might put director at risk of allegation of breach of duty. Ill-informed or ill-advised decisions taken in the management of a company remain management decisions, right? And this is, I mean, there's a lot of references, especially in British case law, on residence. You know, first of all, whether the managers are pushed aside as in the very old cases. I think what is it called, the Yarra Mills case. I'm completely misquoting the name here, but there's also cases where the effective management was in the UK, such as in the Beers case, and then there were cases where the court simply said, you know what, the directors weren't making any decisions. They were simply following instructions, right? That was the case with the 4 companies in Jersey which exercised call options in order to import losses into UK. You can find that case on the channel. I forget the name of it right now. But the court here says, you know, that none of that happened, right? And this is what makes this case special in my point of view. Is it's one of the few cases that the taxpayer actually won. Now, this is the back end of the case. I mean, the Court of Appeal decided that a taxpayer won, but I wanted to look at what the special commissioners actually said. But before we do that, the court concluded, the Court of Appeal, the sole director of Eulalia was ABN AMRO Trust. ABN AMRO Trust entered into the agreement to buy shares from CIL and into the later agreement to sell the shares. Those decisions were taken in Amsterdam. In other words, the company was tax resident in Holland. Now, if we look at the special commissioner's comments, and these were quoted in the case of the Court of Appeal, there are some absolute gems here. If we look here, I mean, paragraph 13 of the Court of Appeal says the circumstances in which Eulalia was acquired and subsequently participated in the disposal of the shares and holdings are described by special commissioners in more details, paragraph 30 to 40, right? And then 30 is a real gem, and 31. Lovell White Durant, the solicitors for the purchasers, wrote to Prudential Venture Managers Limited, who were co-ordinating the offer on 26 July 1996, stating, among others, we have de facto exclusivity, even though they cannot confirm it in writing for tax reasons. The letter mentioned the tax structure and continued. The holding of the Wood family in holdings is held. Some direct and some through trust. So they just described the structure that we looked at before. About 50% of the trusts are onshore and 50% are offshore through the BVI. Apparently the structure set up has now been snookered, I love the word, snookered by the last Finance Act, and they want to get over the point by interposing a Dutch holding company between the BVI company and holdings. You know, and this sentence, it makes you wonder, you know, if you had to look at the structure today under the principal purpose test, what would be left of the structure, right? I mean, it would still be so that the BV would be tax resident in Holland, but I doubt that it will fail, that it will pass the principal purpose test. And then the court continued to quote from the special commissioners in point 39. They said, on 19 July at 12:40, Pricewaterhouse in Manchester faxed to Barclays Trust a draft agreement for the sale of CIL's shares in holdings to Eulalia for 23 million, together with a draft memorandum by Eulalia acknowledging a loan by CIL of that sum to buy the shares, right? The draft agreement provided that if Eulalia should transfer any shares within 3 years to a third party, it should pay an additional consideration of 95% in the excess of the 23.7 million. And then on 23 July, an agreement was signed in identical terms to the draft sale agreement, apart from the insertion of the registered number of Eulalia. Now, I think this is important because it meant that ABN AMRO Trust had at least 4 days to consider the transaction, right? It's not as though they had no time to decide. And then the court goes further to say, or the special commissioners goes to say, on 18 July, following the purchase of its shares by CIL, ABN AMRO became managing director and undertook responsibility for the day-to-day management of Eulalia. It is clear that the appointment of ABN AMRO was at the behest of Pricewaterhouse. Okay? In fact, Eulalia was purchased from an associated company of ABN AMRO. 5 days after the appointment of ABN AMRO, Eulalia purchased from its new parent company CIL the shares of holdings, with the purchase price left outstanding as an interest-free loan. There is no evidence that any consideration was given by ABN AMRO of the basis on which the price of 23 million was fixed. So here is what the special commissioner said, you know what, we don't see any decisions being made here, right? We're just seeing ABN AMRO executing decisions but not considering them. In the present case, the only activity of Eulalia between its acquisition by CIL and the sale of its shares in holdings was the acquisition and sale of shares in holdings and the matters connected therewith. There was nothing else to manage. We infer from Mr. Senior's letter of 30 September to ABN AMRO that there had been little or no contact between Pricewaterhouse and ABN AMRO since the 13th of August. So nothing really happened. They just held the shares. And this is part of what the Special Commissioner argued, right? They said, there was not really anything to do, and to the extent there was anything, that was not decided in Holland. We accept that there was strong commercial reasons for Eulalia to accept the terms of the sale of its shares in holdings, which were acceptable to Mr. Wood and to the managers of the business. It is apparent that there was a considerable goodwill element in the price, which was over twice the net asset value. To a considerable extent, the decision to sell made itself, right? However, it does not appear that any real consideration was given by ABN AMRO at all. The statement by Mr. Wierix, he was the director for Eulalia on behalf of ABN AMRO Trust, makes no mention of seeing accounts of holdings, the disclosure letter by Mr. Dib Lupton Alsop, or of the warranty. So the Special Commissioner just say we don't see them reading any documents to come to any conclusions. We conclude that although there were strong reasons for Eulalia to accept the offer to sell its shares in holdings, no real consideration was given to the matter. Okay. And then they go on to say the only acts of management and control of Eulalia were the making of the board decisions and signing or execution of documents in accordance with those resolutions. We, the Special Commissioners, do not consider that the mere physical acts of signing resolutions or documents suffice for actual management. What is needed is an effective decision as to whether or not the resolution should be passed and the documents signed, and such decisions require some minimum level of information. Where the geographical location of the physical acts of signing and execution documents, and I think this is important, where the geographical location of the physical acts of signing and executing documents is different from the place where the effective decision that the documents be signed and executed is taken, we consider that the latter place is where the central management and control actually abides. And this raises the question of where the place of effective management was situated. We accept Mr. Brennan's, that was from the tax authority's submission, that in the present context there is no difference between central management control and central management and control and the place of effective management, which is a treaty term. There is no indication that any effective management decisions were taken in the Netherlands. Now, so the court said, nothing really happened, and to the extent that anything happened, they were going through the motions, but they didn't make any real decisions. And I want to just make one comment here. The court, the Special Commissioners also say there was a huge capital gain realized, so the purchase price of the shares were not at arm's length at all. Now, there's been a lot of these transactions in that time in the Netherlands. The Netherlands has been used to buy shares cheaply and to sell them at market price. And from a Dutch point of view, it didn't really matter to the extent that you could say that to the extent there was a gain realized, that gain fell under the participation exemption and it was not taxed, And then you can also say, well, ABN AMRO didn't read the documents, but one would assume that the information that PwC gave ABN AMRO or ABN AMRO Trust was, listen, you're going to buy shares for 23 million on day one, and you're going to sell them for 30 million a couple of days later, right? That is all they needed to know. They were managing a company that was going to make a huge profit. There was no real professional liability for them because they were not making any bad decisions on behalf of the company. They were okay. So that decision by itself, to me, means that one could say that ABN AMRO did consider the case and they were okay with signing these documents as directors of Eulalia. But I will leave you with two thoughts. And the first is, whether a court would still overrule a decision based on paragraphs 145 and 146, as the Special Commissioners wrote them here, after BEPS. I am not sure that would happen, but maybe UK specialists would disagree with me. And then the second one is, does the fact that they were resident in Holland even matter? Because you would now run into the principal purpose test, right? Because clearly the Netherlands was chosen for this participation exemption. That doesn't fall foul of the principal purpose test. But if the UK were to tax, and I don't know if they do or did in those days, non-residents for the sale of shares in UK companies on which a capital gain is realized, and those non-residents were not protected by a tax treaty in Article 13, then maybe one could argue that the principal purpose test here would kick in, and they would not get the benefit of Article 13 under the Dutch-UK treaty. I hope you enjoyed the case, and I look forward to us discussing another case next time. Bye for now.